Introduction to Statutes for the students at Boston College Law School. You know the old saying, there ought to be a law? Remember how before you came to law school you thought of law as a legislative enactment, a statute, a law. Then you came to law school and learned about the common law. Common law is sometimes called dog law. You don't articulate a rule to your dog, Lucky, don't sit on the sofa. You wait until something happens. Lucky sits on the sofa, and then you say, bad dog. Common law is like that. After something happens, parties go to court. There they find out who is the bad dog. Now the rest of us know for the future not to do that, but it wasn't explicitly stated before the first dog got on the sofa, the way a statute sets out the rule before anyone does anything. Now here's a little secret. In law school, especially in the first year, you basically read cases. But in modern-day practice of law, there aren't that many purely common law issues. Your law practice professors work hard to develop research and writing problems that are common law based so you can learn the case synthesis and writing skills you will eventually apply to all problems without the added complications of statutory interpretation. But most of today's legal practice is very heavily involved with the application of statutes and sometimes also regulations. Even purely common law causes of action will be limited by statutes of limitations. But today we're looking at statutes, so I've brought a picture of my favorite law, Public Law 101-143, National Tap Dance Day. This is what a statute looks like. It's an enactment of Congress signed by the President, and it is the law. It's called a public law because it affects everyone. There are actually some laws that affect specific individuals, and they're called private laws. Public Law 101-143 means it's the 143rd public law enacted in the 101st Congress, and is published as a session law, which is the chronological publication of all the public laws in one legislative session. Federal session laws are published in Statutes at Large, and you can find this law on page 838 of Volume 103 of Statutes at Large. Here's a different law that operates a little differently. It's the 1938 law that established that November 11th will be the federal legal holiday known as Armistice Day. Back then, public laws were cited to by their chapter number, but this is still a public law. And in 1954, another public law renamed it Veterans Day. And in 1968, lots of federal holidays were moved to Mondays to give us those nice 3-day weekends, and Veterans Day was moved to the fourth Monday in October. A lot of veterans were unhappy with that, and they wrote to their congressmen and protested. And in 1975, Veterans Day was moved back to November 11th with this act. So these statutes are acts, but session laws are not a very convenient way to look at laws. Laws that have changed over time, like the Veterans Day holiday, are also available in a more convenient form called a code. A code is a topical arrangement of permanent general laws. Laws like National Tap Dance Day, which was a one-time event, are only available in session law form, but laws of lasting application appear in the code. This is the section of the U.S. Code that includes Veterans Day. The section actually has all the federal legal holidays. So years after Veterans Day moved back to November 11th, when Martin Luther King Jr. Day and Juneteenth were added as federal holidays, those holidays were added to this same section of the U.S. Code. The U.S. Code is divided into broad subject areas called titles. These titles can be divided into parts, subparts, chapters, subchapters, and sections. When you cite to the U.S. Code, you only mention the title and section number. But if you are citing to a code section that isn't there any longer, you need to include the edition of the code you are using, since the content of any individual section might say something different at some other point in time. For example, in the 1972 edition of the U.S. Code, Veterans Day would be on the fourth Monday in October. And while you can search for statutes on Lexis and Westlaw, there are sometimes other methods of finding relevant statutes that are even easier than looking through a set of search results. For example, you can use the organization of the code to help you find relevant sections using the table of contents. First, choose the correct title, which in this case is Title V, Government Organization and Employees. then you would see that Part 3 is employees, Subpart E is attendance and leave, and within that subpart, Chapter 61 is hours of work, and Subchapter 1 is general provisions. Looking through the sections, we spot Section 6103, holidays. And even if you don't come into a statute through the table of contents, it's always a good idea to look at the table of contents for the chapter or subchapter that any section you are interested in is a part of. Frequently related sections must be read together to understand the law. They might limit the application of a section. The way that 6104 and 6124 explain how holidays are computed for certain types of federal workers. Additionally, there can be more general sections that will have an effect on how a statute should be applied, like 6120, purpose, and 6121, definitions. Another way it is sometimes easier to find relevant section is through a code index. Indexes can be in books, but there are also online indexes to codes that might make it easier to find the most relevant sections quickly. Federal statutes are on Lexis and Westlaw, but they're also available for free from the U.S. Government Publishing Office, both as the U.S. Code and also as statutes at large, the session laws. And they're also available for free from the Office of the Law Revision Council. These are the people who take the session laws and turn them into a code. So this is a very up-to-date version of the code. But finding relevant statutes is only half the battle, because the statute means what it says, but even more than that, it means what an authoritative court says it means. Finding the relevant statutory sections is just the first step in statutory research. You now need to find cases that interpret relevant provisions of the statute, and this is made easier through something called annotated codes. Annotated codes are codes that include the statutory language and much more. The extra thing I want to focus on now is something called annotations, or notes of decisions. And to show you how they work, I'm going to jump from federal statutes to state law. State statutes are published in much the same manner as federal statutes. Each state has its own session laws and statutory code. Sometimes the terminology is different. The federal code is divided first into titles. Some state codes are divided into titles. Some use chapters, some articles, and some have codes that have descriptive names like civil code and penal code. This is an example of the burglary statute from the mythical jurisdiction of Grimes. Its code citation is Grimes General Laws, Chapter 266, Section 14. It's a simple little statute of one sentence. At the bottom are references to the Grimes session laws that enacted and amended this section. To fully understand the section, you may need to read other sections of the Grimes General Laws which might define felony. And the other thing you may need to look for is case law. This is where annotated codes really pay off, because annotated codes provide references to cases that interpret various provisions in this statute. If we wanted to ascertain whether or not a particular structure qualifies as a dwelling house for purposes of the burglary statute, we can use the annotated code to find cases that have addressed that issue for that statute. In addition, cases can rule that a law is unconstitutional. Did you know that in Massachusetts, only medical doctors can be tattoo artists? This is the free version of the Massachusetts Code operated by the Massachusetts Legislature. General Laws, Chapter 265, Section 34 prohibits anyone who isn't a registered, qualified physician from marking the body of another by means of tattooing. Massachusetts General Laws, Chapter 265, Section 34 was held unconstitutional by Lanphier v. Massachusetts in the Massachusetts Superior Court on October 20th, 2000. The court held that both the process and product of tattooing merit First Amendment protection. And there's no indication of that on this when this statute was held unconstitutional on the Mass General Laws. There was no indication that this statute was held unconstitutional on that Mass General Laws website. So, when using a statute, you need to read the words of the statute itself. Then you want to find interpretive cases that help you determine whether the statute in fact applies to situations like yours and is still valid.